Now, welcome again to Court Helicopters Explainer for the weekend. My name is Stanley Kinyanjui. I'm an advocate of the High Court. Some questions arose from the previous explainer that I did on burial disputes, and the questions arose, or rather, gave themselves from the standpoint of the Succession Act. Now, I want us first of all to understand that burial disputes and succession disputes are not the same thing. However, I will touch on a few issues which arose and which questions were posed from the explainer that I did, and those questions surround the issue of intestacy and where a person has more than one wife. Now, as you are aware that once you die, you have the capability of disposing of your assets through a will. And once you do that, then you do, or rather, what the circumstance that you've just created is tested succession. So when you die having not left a will, and when I say a will, I mean a will that cannot take effect, because remember that there are some factors that ought to be considered for a will to be deemed a will. So in the event that you die and die without making a will, or a will that can be upheld as a will, then you die in a manner that we call intestate. So the question therefore arose that if, let's say, person A has, or rather had two wives, and one wife was divorced, the question arises is whether that divorced wife can be considered as a wife for the purposes of succession. Now, Section 3 of the Succession Act defines a wife as a wife who is surviving the deceased or former wives separated. I want us to take that word very keenly. I've used the word separated, not divorced. And I also draw my inspiration from Justice William Musyoka, where the effect of the text is that a divorced wife, having been divorced from the deceased before his time of death, cannot claim as a wife for the purposes of succession. However, and this is extremely very limiting, however, a divorced wife, if they can be able to prove dependency, that is under Section 26 and 29 of the Law of Succession Act, if they can be able to demonstrate that at the time the deceased was dying, he was providing for them, then for those purposes, then they can be considered as a unit, or they can be considered as people who are dependents of the deceased and who ought to take part in succeeding the deceased. Now, moving away from divorcees and people who've been separated, there are instances, and we see this a lot, where a man has died polygamous and he has more than one wife. Let's say, for example, in this case, he had three wives, and each of those three wives, for example, again in this scenario, had two children each. Then how is that property divided? Now, the law of succession brings in a very interesting concept called units. Now, each and every person is considered a unit. And this is, or was done, to bring into effect the principle of equality. Therefore, if these three women have been left and each has two children, then the estate will be divided amongst the children equally, and each of the wife is also going to be considered a unit for the purposes of succession. Therefore, the first wife is going to be counted as herself and her two children. That makes 3 units. The second wife, the same thing. And the third wife, the same thing. So it is actually very interesting that maybe sometimes you see that before a person dies, he has demarcated his parcel of land and probably even gifted, let's say, the first wife portion A, the second wife portion B, and the third wife portion C. Therefore, the question again arises, after this man dies, can any of those women now start coming back to the law of succession to seek more property or to seek any other orders? Now, this concept was argued out sometime, I think, in 2011, and the general consensus is that once a deceased has settled a wife and her children in a parcel of land and another wife in a different parcel of land, in the event that all these women and their children have an equal, let's call it, they have an equal portion of what has been left behind, then most of the time we find that those cases are dead on arrival. But in the event that this person has died and there has been no demonstration that the settling of these three wives was equal or fair, then sometimes, and I have used my words very carefully, sometimes, and this is based on a lot of factors and circumstances, then a wife or a child can go to the court and seek redress. Thank you.